Hi, I'm Mackenzie Sorich, and today I'm going to talk to you about the divorce process in Washington State when you have minor children. In Washington State, we're required to create parenting plans and child support orders when there are dependent or minor children. If you're watching this video, then you might be contemplating divorce or just getting started with the process. It can be overwhelming at first. So today I'm going to break it down to give you a little bit more information and try to feel more confident in what to expect. In Washington, we call custody arrangements parenting plans. Parenting plans must have at least these three essential ingredients. One, they must include a residential schedule that describes what time the children are going to spend with each parent. Two, how major decisions for your children are going to be made. When we talk about major decisions, we mean education, non-emergency healthcare, and sometimes things like extracurriculars or cell phone use, and so on. And then third, there is dispute resolution provision that must go into the parenting plan. This means how are future disputes going to be resolved between the parents? Will they go to mediation or arbitration or court? The next thing to know is that the court will use the best interest standard to determine whether or not the parenting plan is appropriate for your children. Parents are presumed to be able to have equal right to parent their children. And when they cannot agree on what the schedule or the decision-making should look like, then the court's going to consider what's the best interest of the children. And they'll consider things like the children's needs, their developmental stages, and the ability of the parents. Parents have a constitutional right to parent, but sometimes there are safety issues that cause limitations on a parent's ability to spend time with their children or make decisions for them. When a parent has domestic violence history, addiction issues that are untreated, or mental health issues that impact their parenting, then there may be limitations written into the parenting plan. We all know that it's best for children when parents can agree on the parenting plan, but sometimes that's not possible. And when parents cannot decide, then the court may appoint a parenting evaluator or a guardian ad litem to make an investigation and report back on what is the best arrangement for the children. Children get to decide where they live when they turn age 18. That's when a parenting plan ends. So finally, we'll discuss child support orders. Both parents must disclose all of their income when we're calculating child support. Their average monthly wages will be placed into a state-mandated formula that will determine the transfer payment. The transfer payment usually moves from the parent who has less overnight time with the children to the parent who has more overnight time with the children. Child support order will also include provisions for how healthcare is paid for the children, and sometimes things like extracurricular expenses or even college expenses. And then finally, how any child tax deductions or credits are awarded between the parents. Parenting plans and child support orders are mandatory forms that must be used in Washington State, but they require a great deal of customization to meet your family's particular situation and your children's needs. They last for a very long time, so it's important that you put a great deal of thought and consideration into what goes into these. We're here to help. Just give us a call for a consultation.